Hello, everyone. Welcome to another live edition of Employment Law Q&A. My name is Alex Lucifero. I'm an employment lawyer and partner with Samfiru Tumarkin, LLP. We are the employment lawyers across Canada and specifically in British Columbia, Alberta, and Ontario. This is a live Q&A, a live stream right now coming to you live and ready to answer any and all questions when it comes to employment law, when it comes to your workplace. If you're dealing with any issues at work, if your employer is asking you to do something that you don't feel comfortable doing, if you've been let go from your job, certainly, if you just have some sort of issue at work, it's extremely important to know as an employee, you have rights, you have options. Our employment laws in Canada are actually quite protective of employees. There are lots of different things that employers can't do when it comes to your employment rights. But of course, if you don't know what those rights are, what those protections are as an employee, the law can't help you. And so this is an opportunity right here, right now, and for the next half an hour to get educated on what your employment rights are. And of course, to ask any questions when it comes to your employment rights and specifically the situations that you're dealing with. Do also keep in mind, if you're dealing with medical leaves of absence at work, if you've been injured at work, or if you've been injured outside of work, if you're dealing with some sort of health issue and you need to take time off of work, we do also assist employees with disability insurance claims. If you have disability insurance coverage through your employer, it's certainly possible, if you're medically not able to work, that you qualify for disability insurance. Employment lawyers often deal with these situations, disability insurance lawyers as well. And it's important to know, again, as an employee, insurance companies will oftentimes give you a hard time when you're applying for disability insurance, whether that's short-term disability or long-term disability. Insurance companies aren't really too keen on paying employees when they're medically unable to work. They'll find some sort of excuse to deny a claim. If you have any questions about that situation, disability insurance, if you have any questions about medical leaves of absence at work, if your employer is giving you a hard time about taking time off due to a medical issue or a health issue, again, go ahead and post your question right now. Don't ask about family law, don't ask about criminal law, but if it has to do with your employment, if it has to do with medical leaves of absence and disability insurance, go ahead and post your question right now or over the course of the next half an hour. You don't have to mention any specific names. You don't have to give your employer's name. Ask a general question, keep it confidential. And I promise you, by simply asking that question, you are going to be on the road to resolving your workplace issue. A lot of times these issues can be resolved quite easily. In fact, the law is very straightforward in a lot of situations. And even where the situation is maybe a bit delicate or a bit complicated, again, simply knowing what options you have, what you can and can't do, extremely important from an employee's point of view and from an employer's point of view as well. Mind you, if you're an HR person, we've had HR representatives tune into these live streams to get a bit of a sense of employment law. If you're an employer of a small business or medium-sized business or an HR representative, go ahead and ask your question on behalf of employers, and I'll get to those as well. Happy to help anybody in the situation that, again, is dealing with a workplace problem. That's what we're here to do today. We're here to talk about employment law and workplace disputes. As usual, a couple of initial items on the agenda. Number one, I want to share our contact information so that if you want to reach out to us off live stream and off air, you can go ahead and contact us at the office. First place to visit, and it's on the screen right now, employmentlawyer.ca is where you want to head first for a couple of different reasons. Number one, of course, it's got all of our contact information. Our phone number to call the office will be there. It's a toll-free number. Of course, all of our email addresses, if you want to reach out to somebody individual, are all on the website as well under your team, under the banner Your Team. But as well, you have a ton of resources on our website, articles, blogs, news posts, videos, lots of different stuff to just, again, start getting an initial sense of the situation. You can also email us. Another great way to contact us. help@employmentlawyer.ca is the email address. help@employmentlawyer.ca. It's on the screen right now. Go ahead and send us an email. It is completely confidential. Whatever you say in that email will stay there. There's absolutely a very strict confidentiality obligation when you're speaking with lawyers. and go ahead and simply just give us a brief description of the situation. Don't send us a 2-page email telling us every single event that ever happened over the course of 10 years of employment. Send us a little bit of background and your question, and I promise someone will get back to you if you email at help@employmentlawyer.ca. That's a way, guys, to get a hold of us off air. Again, you can go to our website and just give us a call. If that's easier, go ahead and give us a call. We have an entire team of intake staff standing by to take your calls, call people back, schedule meetings with lawyers, etc. So go ahead and contact us at the office. But if you're tuning in right now, once again, this is a live employment law Q&A. My name is Alex Lucifero. I'm a lawyer with Samfiru, Tumarkin, LLP. And go ahead and post your question. I see already a couple have popped up already. Let's line up some questions, guys. So please, if you're looking at this right now and tuning in right now, again, keep it generic, keep it simple. Whatever question you might have, whatever issue you might be struggling with. Maybe you have a question about your pension plan at work. Maybe you have a question about what kind of severance you might be owed if you're ever let go. Even if you're not, you're not on the chopping block, so to speak, right now. If you're wondering what your severance entitlements might be, give me your age, position, and years of service. Give me those 3 factors, and I promise I will give you the information that you need to get a sense of what your severance entitlements would be. All right. Just as we're lining up those questions, and please go ahead and post those right now, I wanted to talk about a matter that came across my desk earlier this week. I do the radio show in Toronto for the firm, and I spoke about this on the radio, and it received some pretty good feedback. So I wanted to share the story here as well. This is a great lesson for employees that have been let go from their employment. And the moral of the story is it's important to focus on the right things once your employment has come to an end. So spoke to a very nice older lady. This would have been late last week now. And this lady had been let go from her job after about 11 years of service. She had been with the same company for 11 years. And this lady contacted me. She sent me an email, actually, and she said, "Hello, I'm just wondering, how long does an employer have to provide a record of employment and vacation pay after you've been let go?" So this lady had been let go from her job after 11 years of service, and she was offered some sort of severance from the company. But her question wasn't about severance. Her question was about her record of employment, because she wanted to apply for employment insurance. And it was also about whatever vacation pay she might be owed. She wanted to know, how long does it take to receive those things? And so I wrote this lady back, and I asked her, well, can I have a little bit more details about the termination? And it turns out she was offered 5 months of pay as her severance entitlements. And so the very first thing I told her is, listen, don't worry about the record of employment and the vacation pay. The company has a week or until their next payroll date to provide those. So those are coming, no matter what. You'll be able to apply for employment insurance pretty quickly. And that's what employers have to do. But there was a bigger issue at play here. The bigger issue was, again, this lady had been employed with the same company for 11 years in an administrative position, nothing overly complicated or fancy. She wasn't earning a ton of money. And she was in her early 60s, I believe, if I remember correctly. And so I told this lady, listen, I appreciate the questions about the record of employment, but your severance entitlements here are actually the major issue. Your severance entitlements as an 11-year employee in her 60s in an administrative position are going to be in the range of 12 months of pay. That is 1 year of full pay that this woman is owed as her severance entitlements, wherein she was only offered 5 months. She was literally offered less than 50 cents on the dollar as compared to what she's actually owed. So, I mean, in that context, listen, forget about the record of employment, forget about your vacation pay. And of course, those things are important and they'll get dealt with in time. But you're actually owed tens of thousands of dollars more than what the company has offered. This is what we need to be dealing with. This is what we need to be discussing here. And this lady was absolutely shocked. She had no expectation of any more severance than what she was offered. She thought what the employer was doing was the right thing. She thought what she was offered was what the law provides for, right? She was just blindly trusting her employer that If they're offering X amount as 5 months of pay, that's what they owe her. And so as long as the administrative stuff gets settled, she's good to go. And that's not the case. The lesson here is that do not just assume that what your employer is offering you as severance pay is correct. Even if they say it's as per the law, or even if they say it's as per your employment contract, perhaps, do not assume that the severance you're being offered is the correct amount of severance. Make sure you speak with an employment lawyer in the circumstances. Chances are, and we see this every single day, chances are your employer owes you more than what they have offered you initially upon termination. The good news for this lady is that it's not going to be complicated to get this lady her proper severance entitlements. This is a very, very straightforward case, particularly given her age and years of service. And so we're going to be working with her now moving forward to get her proper severance entitlements. She's going to get the record of employment. She's going to get her vacation pay. But more importantly than that, she's going to have financial security for a year. And that's exactly what she's going to need in this job market, in this economy, to make sure that she can go out there and find another job and that she's not harmed financially as a result of the loss of her job. So great lesson out there for all of our listeners. If you, a family member or a friend, if you know anybody that's been let go from their job, please spread the word. Do not just simply sign on the dotted line without thinking or without receiving advice. Do not accept the severance offer at first instance. You want to make sure you get advice, professional advice. The person you need to speak with when it comes to severance is an employment lawyer. And even if the offer is reasonable, right, have an employment lawyer tell you that, right? I'd be much happier if we spoke and I was able to give you my blessing, so to speak, on what a fair package looks like. If that's the case, great. The employer's done the right thing. The unfortunate thing is that that is actually quite rare to see. Oftentimes, an employer will offer less than what an employee is actually owed. And from the employer's point of view, it's simply a business decision, right? They're looking for a good deal, like any business, like any corporation would. They're looking for value, right? And the employee needs to do the exact same thing on their end and making sure, from a business perspective, that their interests are protected, that their rights are protected as well. All right, guys, let's get to the questions at this point. Thank you to all of you who have asked. Let's go. Jay, David, Tanya, Caramella, thank you all so much for posting your questions. Just for those of you tuning in mid live stream, once again, my name is Alex Lucifero. I'm an employment lawyer and disability insurance lawyer with Samfiru, Tumarkin, LLP. This is a live Q&A. Go ahead and post your question. I'm here to answer questions. I'm not here to speak, to preach from the front of the church or the pulpit constantly. I'm here to answer your questions. So please go ahead and ask them. That is what we're getting to right now. All right, guys. Jay is first in line, and he asks, are employers required to call back their employees in order of seniority, or do they have freedom to select whom they choose? Jay, excellent question. This is on YouTube. Jay asks. Jay, the answer to your question depends on a couple of different factors. So let me break this down for you. Number one, it depends on whether you're unionized or non-unionized. If you're a unionized employee, Jay, and you're talking about a layoff, right? You're obviously referring to employees being called back to work. That implies that these employees are on temporary layoff. Then, Jay, it's very, very likely that it is by order of seniority and length of service. And so if you're a unionized employee and you're having issues with being called back to work, maybe after other employees with less seniority have been called back, you've got to speak to your union. And that's really the only thing that you can do, Jay, as a unionized employee. Look at your collective agreement. The collective agreement is basically the contract, the employment contract between the union and the employer. Those are the rules of the game as a unionized employee. The collective agreement, or collective bargaining agreement, as it's often called, are the terms of employment that govern the employment relationship. Again, they're the rules of the game, right? So have a look at that. There might be a section on temporary layoff, and there might be a section about priority in terms of calling back to work that might have to do with, again, seniority, as you mentioned. If you're having an issue in that respect as a unionized employee, then you got to speak to your union rep about it. You cannot, unfortunately, speak to an employment lawyer or get outside advice on the subject if you're a unionized employee. There are many, many perks guys, to unionized employment. You have more job security. You might have better benefits. You might even have better pay sometimes, depending on the particular industry. But you are bound as a unionized employee, again, by the collective agreement and by your union. Your terms of employment live and die by what your union decides. We saw that many, many times when it came to the issue of vaccination against COVID-19 and mandatory vaccination policies. Employees had to go along effectively with whatever the union decided in that respect about COVID vaccination, whether it was a requirement or not to work. And it's the same thing, Jay, when it comes to temporary layoffs. So if you're having issues as a unionized employee, speak to your union. If you're a non-unionized employee, Jay, then the issue here changes significantly. A couple of basic points, and I'm going to get to the other questions as they're coming in. But I want to give this its fair due because it's an excellent question. Again, guys, we're talking about temporary layoffs here. If you are a non-unionized employee and you've been temporarily laid off, the first most important thing to note is that your employer doesn't necessarily or inherently have the right to temporarily lay you off. You may be able to dispute the temporary layoff, treat it as a permanent termination, get severance, and get moving on to new employment. And that is almost always the better option. It makes absolutely no sense as a non-unionized employee, right? Unless you're working in a seasonal job where you know you're going to be laid off every winter, for example, right? You're in construction. You take, a few months off in the winter when you can't do any work. That's okay. I have no issues with those kinds of temporary layoffs, right? And those are that's the industry, so to speak. But in any other industry, right? If you are out of nowhere temporarily laid off and you were not expecting it and it's not an established term of your employment, it is far better to treat that layoff as a termination, because what a layoff is you're basically sitting on the bench, right? You're sitting at home, not collecting any pay whatsoever for as long as 8 months potentially. That is a long time to go without pay. It's completely unreasonable. So as a non-unionized employee, number one, don't just assume temporary layoffs apply to you. Right? If you're laid off, you need to immediately speak to an employment lawyer. We need to look at your employment contract. We need to talk to you about whether you've ever been laid off before or not. And if there's nothing in your contract about layoffs and you've never been laid off before, right, then it makes much more sense to just treat the layoff as a termination. Get your severance entitlements. Severance is going to be based on your age, position, and years of service. It's not going to be a couple of weeks. It's not even going to be a couple of weeks per year of service. Chances are it's going to be several months of severance, if not more. So your severance entitlements may be significant, even if you've only been with the company for a few years. And then secondly, Jay, if you've accepted the layoff and other individuals, and again, you're a non-unionized employee, if you're already on layoff, you've accepted it, maybe it's a term of your employment, right? Maybe you're comfortable with being temporarily laid off, but other employees are being called back to work. Again, as a non-unionized employee, you probably don't have the option to fight that situation. An employer can call back whomever they like from a layoff in whatever order they prefer. There's no rhyme or reason for a non-unionized employee. But again, the most important point as a non-unionized employee, do not just assume temporary layoffs apply to you. You need to consent to a temporary layoff, and actually, you shouldn't be consenting to a temporary layoff, at least not without speaking to us first, without speaking to an employment lawyer first. Excellent question, Jay. Thank you so much. It's a great way to start the Q&A. All right, next up in line is David on Facebook. David asks, I have been employed salaried for over 10 years. Now they're asking us to sign a contract to switch to hourly. Should I agree to this? Another excellent question. Guys, thanks so much. These are sophisticated questions that are extremely relevant, extremely pertinent to employment law issues. So thank you so much. David, the answer to your question is this. If the switch from salaried to hourly is going to potentially have an impact on your total compensation, right? If they're at the same time maybe limiting the amount of hours that you can work, right? Or if you just do the math, you realize that the hourly rate that you're receiving is going to ultimately mean that you earn less than what your salary is right now. In other words, if there's going to be a significantly negative change that occurs compensation-wise from moving from salary to hourly, right, then I would not agree to it, right? If there's going to be no change whatsoever, if it's basically confirmed that, listen, we're moving from salary to hourly, but your pay is not going to change one red cent, right? If that's the case, not a problem at all. You can agree to it, David. It's not an issue as long as your pay isn't changing. Of course, if your pay has the potential to increase because you're now on an hourly wage, right? Then that's great. I would go for that as well. What I would do in your situation, and I've got two pieces of advice, David, in this respect. Number one, if as part of this change from salary to hourly, you're being offered some sort of new employment contract, right? So maybe they're proposing that, but they're asking you to sign a document that's 2, 3, 4, 5, 10 pages long, right? And that's the major change, but there might be some other stuff in there that you've never seen before. Do not sign without speaking to us. Give us a call at the office, send us an email at help@employmentlawyer.ca. There could be terms in that contract, David, not just the salary change stuff. There could be terms in that contract about termination, about severance, about layoffs, about non-competition. There could be stuff in there that really limits your rights and options moving forward. Before you sign off on something like that, again, let's have a chat about it. Let's make sure that your rights are protected moving forward. The second point I would make, David, is if they're just, in an email or in a very simple document, they're asking you to effect this change, again, from salary to hourly, what you might want to do is respond back in writing. You want a record of this to be clear, right? You want to be able to rely on this written evidence, and it could just be an email, right, moving forward if need be. But you probably want to write back and say, I will agree to this change on the condition that my pay does not change in a negative way, right? So you want to make you agreeing to this conditional and make it clear that you are not going to be accepting any less pay than what you're earning right now as a result of this change. In other words, your agreement to the change is conditional on them assuring you that you're not going to be earning less, right? And if they write back and say, yep, no problem, that's agreed, then you're good to go, right? And that's excellent. If they refuse to accept that, right, that's a red flag, right? So if they say, well, sorry, we can't commit to, we can't guarantee you'll be earning the exact same amount. Your hours might change, this, that, or the other. If that's the case, David, then I would hesitate. And I don't know if I would, it could be that they're planning on reducing your compensation, your total income. And in that case, sorry, I wouldn't agree to that kind of change. I'd stay on the salary. These situations, David, are quite delicate, quite complicated. I would say before you respond to your employer, let's have a conversation. Again, reach out to us at the office, visit employmentlawyer.ca, email us at help@employmentlawyer.ca. Let's schedule a quick call. Let's figure out what's what. I want to take a look at your employment contract if you've been offered one. I want to know more about the details, how long you've been employed with the company, et cetera, and we'll figure out exactly what the right approach is moving forward. All right. Tanya is up next on YouTube. Tanya asks, can an employer audit your payroll for any reason? I'm not sure what you mean exactly, Tanya. I mean, the short answer is probably yes. An employer can, of course, audit its payroll, right? The payroll presumably is the company's payroll, the employer's payroll. If you're an employee of the company, right, and they're asking you to perform an audit, right, or they're hiring perhaps an accounting firm to audit their finances or their payroll department, yeah, of course, that's kind of well within an employer's rights. Tanya follows up. Maybe this provides some clarity here. I received notification that I owe 8 hours of holiday pay several months later, stating I wasn't in payroll status. Can it be waived through no fault of my own? Difficult to understand the question, Tanya, but it sounds like you've been overpaid vacation pay or holiday pay, and now several months later, the employer is coming back and saying, "Oh, we made a mistake. We need to revisit this." It's a good question, Tanya. So I would say if there's a genuine issue here that they can prove, right, and the proof is in the pudding. You need to see this in black and white, and you need to understand what the employer is saying. If they can prove and you can see very clearly that you are accidentally overpaid vacation pay or holiday pay, even if it's been a few months, your employer can come back and correct that mistake. Right? If it was an honest mistake and you were overpaid by an administrative error, right, or somebody made a mistake and overpaid you, they can try and claw it back, and that would be reasonable enough. They should be willing, however, Tanya, to play ball in the sense that you can agree to some sort of, repayment plan, right? Where maybe you pay $100 off every paycheck to make them whole for that 8 hours that they overpaid you, right? You don't have to pay it in one shot. And again, it's important to very clearly understand, right? And see for yourself. Don't just take their word for it. See for yourself. Show me the documents confirming, in fact, that I was indeed overpaid, right? Show me the calculations. Show me the breakdown. If they can show you that and it's very clear and it's confirmed that you were in fact overpaid, they can ask for the money back. All right, next up in line, Karamala asks, I'm returning from mat leave after 18 months. I was a sales manager. I'm now being told the position no longer exists and a new role will be created for me. It will no longer be a managerial position. What are my rights? Another excellent question from our very educated, very sophisticated viewers and listeners. Thanks so much for the question, guys. These are excellent. Caramella, you have options here. So number one, it needs to be stated that if the sales manager position that you left when you first went on mat leave, if it truly no longer exists, right? And I'm not talking about here you being replaced in the position, right? So if there's another sales manager within the company, right, and they've just decided to give the job to somebody else, that is a massive, massive problem. That's a breach of the Employment Standards Act in Ontario. It's potentially a human rights violation. There are so many issues an employer is going to have if they try and replace someone coming off mat leave. You can't do that as an employer. You need to return the employee to the position that they left if it still exists. Now, if the position genuinely and truly no longer exists, right, they do have also the right, or rather the responsibility, they have the obligation to look for a comparable position. If that comparable position doesn't exist, Caramella, and you have to, again, similar to Tanya's question, you have to know this genuinely, right? So you have to look your employer in the eye, so to speak, and be convinced that there's well and truly no comparable position within the company for you. If there is a comparable role and they're just not placing you in it, again, that's a problem. That's illegal, effectively. An employer cannot do that. So taking the employer at face value here on a couple of initial points. One, if it's the case that your position well and truly no longer exists. And two, if it's the case that there is really no other comparable position within the company for you, then you have two options, Caramella. Number one, you can accept this lesser position if the pay is going to be the same and you like the position anyways, despite the fact that it's not managerial. Listen, you have the exception, you have the option rather of accepting it or not accepting it, right? That's within your rights as an employee. Even if it's a demotion, you can accept it if you're interested. If you're not interested, however, your employer owes you severance. And actually, in addition to your age, position, and years of service, your employer is going to owe you more severance because you're returning on from mat leave, and because it's likely that in your situation you're going to be owed additional amounts simply because it's going to be more difficult for you to find the job coming off mat leave, not having worked for 18 months. One more question, guys. We're going to slip this under the radar. We've got about a minute left here. Very quickly, rapid fire. Shay asks, I worked for a large medical clinic in a physio department. My department was bought out by a different company. I'm currently on LTD. So employers changed. It's been bought out, but Shay's on a medical leave of absence on disability insurance. If I return to work and I'm still employed by the large medical clinic because the physiotherapy department changed hands after I left. Shay, sorry, that's not necessarily a question, but the reality is, despite the fact that there's been a purchase and sale, Shay, despite the fact that technically maybe the name on the paycheck has changed because there's been a new company kind of taking over, nothing changes from your point of view. You have the same rights, the same protections coming off of a medical leave of absence as you would even if it was with the previous company. So if you're cleared to return back to work, they have the obligation to return you back to work to a comparable position. And if they can't do that, right, genuinely can't do that, then you're owed severance, right? If they decide that they don't want you back, maybe because you're on medical leave, that's discrimination. They cannot punish you. They cannot treat you differently in a negative way because you're returning on from medical leave of absence. We'll have to leave it there, folks, but do not worry if I wasn't able to get to your question. We have a ton of these live streams coming up, so do look out for the next one. It's going to be Monday, July 31st at 3 p.m. Eastern Time with my colleague Luke. Luke is an exceptional lawyer, so if I didn't get to your question here, make sure you ask it on Monday at 3 p.m. Eastern Time. Until then, wish you all a good rest of the week, a good weekend. Thank you all so much for tuning in. Have yourselves a good rest of the day as well. Take care. Bye-bye.